Hello, everyone, and welcome, and thanks for joining us this evening. My name is Rosina Bimji, ODHA President. I'll be hosting this town hall with Emily, who's going to be my co-host. I'd also like to take a brief moment to introduce the other ODHA staff and board members who are here with us tonight. We have our ODHA CEO, Mark Harrington, with us tonight, as well as Member of Engagement Coordinator, Emily Bain. You can see her on the screen as well. From our board of directors, we have Heather Kleinberg, our president-elect, in attendance, as well as Michelle Obe-Simmons, director for Region C, Amy Curry, director for Region D, Salima Gina, director for Region E, Suzanne Hoodfar, director for Region F, Alana Mendronis and Renata Albanese, directors for Region G. Welcome, everyone. I would just take a few minutes to do some small housekeeping remarks before we begin. Due to large number of participants in tonight's meeting, we have automatically muted your microphones so that you can keep the background sound to a minimum. The first portion of this town hall meeting will be 45 minutes in presentation on employment law. The presentation will then be followed by Q&A, where you will be invited to type in your question into the chat box or raise your virtual hand so that you can unmute and ask your question. When you registered, you had the opportunity to submit a question in advance, and some of the most commonly asked questions will be addressed tonight as well. We recognize these are sensitive issues, and we invite you to feel free to change your name as it appears on the Zoom screen if you would like to remain anonymous. If you wish to do this, can you please change your name by hovering over the cursor over your name, clicking on the three dots that appear in the corner of your screen, and then clicking rename. I will give a few minutes if you need to do that. And you can feel free to turn off your cameras if you do not wish to appear on the screen. Please also rest assured that we will not be using or sharing your names with any external organization in any way, nor we will attach any of your comments to your name. This presentation is being recorded and will be available on ODHA website to all the members to access by logging in into the ODHA website to be able to see the presentation. Sometimes when you are in the viewer speaker and the slides will not show, if you're using a tablet or smartphone, you may notice that your screen displays the speaker, but does not display the slides that are being shared. If so, make sure that your speaker, your active speaker view is on a gallery view. For iPad, to switch from active speaker view, tap Switch to Gallery View in the upper left corner of the Zoom window. And if you don't see that control, just tap on your screen and let the controls appear. And then you can switch to the view we need to be in for these slides to show up. Is everyone okay with that? We can move on. Emily, maybe I'll give a few minutes for them to switch. Okay.
I think we're good to go.
We're good to go? Okay. I would now, I would like to take a quick poll, take a few moments for those who have joined us tonight to just an anonymous poll. Firstly, please let us know how long you have been in dental hygiene practice.
The poll should appear on your screen. Yeah, I see responses coming in.
Maybe I should vote too. Here we go.
Yeah, sure.
Okay, we got the poll is closed.
I will close it now. And there you should see the results on your screen. Looks like a large percent, 70%, more than 20 years in practice.
Wow. Welcome. And we have a second question. And let us know which part of the province you're working in. So Emily will put up the poll.
Here we go.
Okay.
Okay, I'll share the results.
Thank you. Greater region of Toronto.
Yeah, lots from Toronto and lots from around the province. A nice distribution.
Yeah, for sure. Well, welcome everyone. Thank you for taking those two polls. So I'd like to then move on to our next order of business. One of our main goals as your provincial association is to support you in your practice so that you may focus on the essential oral health care you provide to all Ontarians. It is important we create opportunities to hear directly from you about your practice experiences. We have heard loud and clear from our membership that workplace issues are top priority. And after last year's town hall, if you remember, many requested a live webinar specifically addressing employment law. Here is the agenda for the evening. Our presentation will broadly focus on the issues identified most frequently by our membership, matters related to scheduling and pay, workplace safety, contracts, harassment in the workplace. And as I mentioned earlier, we will also be sharing some of the commonly asked questions or common scenarios, and we'll also be welcoming other comments and questions in the chat box. And now here to provide you with some examples of some of the issues at hand is our own Brooke Auld. I will just share a brief bio about Brooke. As a former policy advisor and a legislative assistant in Ontario's Minister of Labour, Brooke has strong grasp of workplace legislation and a deep understanding on how government policies and decisions can be used to assist her clients. A true political enthusiast, Brooke closely follows current events and isn't ashamed to admit she frequently reads Hansard. Brooke has experience assisting both employee and employer clients navigate their employment relationships from beginning to the end and anything in between. Brooke is a strong advocate for clients and values working collaboratively with them and opposing counsel in order to achieve the best results possible prior to litigation. That being said, Brooke has represented clients before various tribunals and counts such as Ontario Labour Relations Board, the Ontario Human Rights Tribunal, and the Superior Court of Justice. When not working, Brooke enjoys walking her unruly English Springer Spaniel for long walks and working as her partner's sous chef. Brooke, thank you for being here with us tonight. I will now give the floor over to you.
Hi, everyone. Excuse me. I'm so excited to be here this evening to speak with you. And Rosie, thank you so much for the very kind introduction. And yes, as I said, I'm really looking forward to be here to speaking with you about employment law, specifically how it applies in Ontario. Before we get into the presentation, I want to reiterate that my goal in this presentation is to equip you with an overview of employment law and the employment law standards generally in Ontario, as well as the health and safety requirements. But that said, it shouldn't be taken as legal advice, especially as you'll hear throughout my presentation, there are so many different factors and variables that are considered in each situation that we talk about that really no two matters, no two issues, no two situations are the same. As Rosie mentioned, we have left some time for questions at the end, and I was shared many of your questions that were asked in advance. So I've tried to build that into the presentation as well. And you'll notice as well, I'll try to give you some names of resources throughout my presentation that if you do still have questions, you can utilize those resources. Many of them are available online through the Ministry of Labor or other organizations, and most of them are free to you to use as you please. So let's get into the presentation about employment law. As Rosie mentioned, this is the very quick agenda that I'm going to be talking about tonight. For the most part, the first part, I'm going to talk about employment standards under the employment standards legislation, which addresses many of the first set of questions that were mentioned earlier. And the second portion is going to cover health and safety under the Occupational Health and Safety Act, but I will talk a little bit about human rights as well. So the Employment Standards Act, maybe you've heard of it, maybe you haven't. It's a piece of legislation in Ontario. Most provinces have their own version of it that sets out the rights and requirements for employees in Ontario. So I say employees with a bit of a caveat that it applies to most employees. There are some limited exceptions under the legislation. For example, myself as a lawyer, many of the employment standards don't apply to me, and there's other caveats as well. Another important caveat is for contractors and those people who are self-employed. That is a totally different topic of presentation, but I just wanted to flag from the get-go that I will really be talking about the employee and employer relationship as well. I did notice that this topic I know is very probably popular for ODHA members, and I did notice that the ODHA website does have general information about this distinction through employees and contractors if you're interested in that. But as I mentioned, a different topic. So the Employment Standards Act, I'm going to refer to throughout my presentation as the ESA. That's just a short form that we use for the legislation, and it'll be easier for you to follow. The Employment Standards Act and the enforcement of it is overseen by the Ministry of Labor. And that's one of the resources I wanted to mention, that the Ministry of Labor website has a lot of information about the topics that we're going to be covering tonight and is a really great resource if you click and you want to know what your talk or what your question is about, let's say vacation pay or something like that, you're easily able to find it online. So it's important to say that the Employment Standards Act, or the ESA, sets out the minimum requirements for employers and employees in Ontario. So certain minimum requirements that we'll talk about tonight are things like minimum wage or vacation pay or vacation time. Those are the minimums. Other things that it talks about are maximum hours of work, or making sure that there's no reprisal, meaning that your employer doesn't do something if you raise a complaint or if you ask a question about your employment standards, or if you are one of the registered dental hygienists who does hire your own employees, that you're making sure that you're not taking reprisal against an employee who raises questions to you. One thing I wanted to mention is, in line with these, the ESA being the minimums, it's very, very possible that your employer provides you with something more than what the legislation requires. That's great, and that's very common. And we usually refer to that as a greater right. And that's something that you can look at to see if it's in your employment agreement, if you have one, if there's policies in the workplace as well. But the most important thing to remember is that these employment standards are the minimum, and you are entitled to those minimums by law. One of the things that's important to remember as well is that many of the day-to-day issues that we see aren't actually covered under the legislation, under the ESA or otherwise. For example, something that we see quite frequently is providing health benefits. Your employer might provide you access to well, one of the things that you deal with, I'm sure, on a day-to-day basis, dental benefits or prescription drugs, that type of thing. Your employer is not required to provide those benefits to you. Many employers do, but if they do provide those benefits, there are requirements under the legislation. So that's something that's not an employment standard. Same with providing paid leaves of absence. There are unpaid leaves of absence under the ESA, but your employer, for the most part, is not required to provide you under the legislation with a paid leave of absence. Something that I get asked all the time is, well, what if I'm okay with my employer not giving me one of the minimum entitlements? And that'll make a bit more sense once we talk about what some of those minimum entitlements might be. But what if you want to agree to something less than what the legislation requires you to? Or what if your employer asks you to agree to something that's less than what you're required to at law? Under the legislation, you're actually not allowed to what we call contract out of the Employment Standards Act. The reason why this piece of legislation is so important is because it's basically a rule book for employers and employees in the province of Ontario to know what the minimum standard is and what to meet it. And part of that is that you can't agree to something less than that, even if you want to. You shouldn't. You shouldn't agree to it, and you're not allowed to. One more thing that I forgot to say that I wanted to mention in the last slide about what aren't employment standards um, is, I know that many of you probably have employment agreements. Many of you probably don't have employment agreements. That employment agreement, if you do have one, is a resource that's very important for you to understand what you've agreed to and what those entitlements are, and to make sure that you are familiar with it. And that if you have questions that aren't covered under the legislation, that you're checking that piece of employment, that your employment agreement that you signed to. So we're going to talk a little bit about the employment standards. One of the ones that is, most common is, sorry, I think I'm on the wrong slide here. Give me 1 second. Here we go. There we go. Sorry, my slides got mixed up there for a second. Okay, so I'd like to talk about some of the employment standards that employers and employees should be aware of, and many that probably apply to you in your day-to-day life, in your practice. So under the Employment Standards Act, the payment of wages is something that is covered. Your employers or you as an employer are required to establish a recurring pay period and recurring pay days. And employees are required to be paid those wages that have been earned during the pay period by those established pay days. Having a regular payday or a regular pay period, it can vary. It can be weekly, it can be bi-weekly, it can be semi-monthly, monthly, and it also doesn't need to be the same for every employee. But in most circumstances, your employer can change your pay period, but there are some certain caveats. So it is important to make sure that you do have a recurring pay period. You know when you're getting paid and that your wages are being paid to you in the timeline that your employer has established. Another employment standard that's important that many people know about, it's often in the news, is the minimum wage. In Ontario, on October 1st of every year, the minimum wage is increased. Right now, it's $17.20 an hour. Something that many people are surprised to learn is that if you are a salaried employee and you earn an annual salary versus an hourly rate, your annual salary also has to meet this standard depending on the hours that you work. So that's something that people are surprised to hear. They think, oh, well, I receive a salary that covers all my hours of work. And again, there is some important caveats, but for the most part, if you work X amount of hours, and you divide it by your base salary, and it works out to something that's less than the minimum wage, there may be a problem. And your employer may not be complying with your minimum entitlements under the legislation. This was a topic that was very popular in some of the questions, and that's around the hours of work. So the hours of work are set out in the employment standards legislation. There are some important caveats, some of which I will go over, and it does really depend on the individual employee and the employer as well. But generally, for the most part, as it says on the slide, 8 hours per day is the general hours of work, but you can also agree to work more than that in a day, because your employer and you can agree to a certain schedule so long as it meets the other requirements. So I will admit this section of the legislation is a little bit of a maze. So there's a lot of generalities. It depends on what you agree to. You also have to read this. So it can be a little confusing. And generally, the weekly threshold is that you can't work more than 48 hours in a work week. There's also overtime, which many people will be aware of. And for most employees, whether they work full-time, part-time, whether you're a casual worker, overtime begins after you've worked 44 hours in a week. Any hours after 44 hours have to be paid at the overtime pay rate, which people normally refer to as time and a half, which is really 1.5 times your regular hourly rate. So let's say an employee has a rate of pay that's $25 an hour. Their overtime rate will be $37.50 an hour. Something people are generally interested in learning as well is that overtime doesn't necessarily have to be paid to you as dollars and cents. Employers can provide employees with lieu time, which is time off instead of getting the pay for the overtime that you receive. So as I mentioned at the beginning of the presentation, there are often a lot of caveats, and this is one of those areas where there are some exceptions or some caveats to think of. Employees can generally work more than the daily limits of hours that I talked about or the weekly ones. And many of those requirements mean that an employer and employee have to enter into a special agreement to do that. Employees are still entitled to overtime, even if they have an agreement to work above those limits that I just talked about, if they do come to an agreement. Certain positions, like managers, are not entitled to overtime pay, with the very important piece that the work that the manager does has to actually be supervisory or managerial in nature. You can't just call someone a manager to avoid paying them overtime pay. There's, tests that have to be followed in order to see if that's an actual valid exemption. And something that many of you may have or you may have never heard of before is that employers can pay overtime over a longer period of time and not just weekly. This is typically found in something called an averaging agreement, where your employer, for example, if you work one week that's typically very busy and another week that's not, or you have some variation in your hours, employers are able to put in some agreement where you average the time to make sure that the overtime and the pay and the hours are looked at over a longer period of time instead of a shorter period of time. So that's something to think about. You may be like, oh, I was asked to sign something like that as I'm talking. So that's something to think about as well. Or your employer, may one day asked to do that, and you can think back and say, oh, I actually remember that that's something that they can do. Or if you're an employer, that's something that you may want to consider doing, just depending on the workforce. So we've talked a little bit about the requirement to pay employees for work. You're paying them the minimum wage, at least. And we've talked generally about the limits on the hours of work, either weekly or daily. The next important topic to talk about that the ESA covers, and again, a lot of your questions were about this topic, is what is considered work and when is it considered to be performed under the legislation. So very broadly, under the legislation, obviously, when work is considered to be performed when the employee is actually doing work, or if the employee isn't working but is required to remain at the workplace. Let's say you're not allowed to go somewhere for a break, or you have to stay in the office, or you have to stay in the workplace and you're not performing work, typically that is still considered work under the legislation. Another period of time that's typically considered work is also training time that's required by the employer or required by law. We'll get into this in the second part of the presentation, but it's a good segue or a good link is, many requirements under the health and safety legislation require that employers provide some form of health and safety or workplace violence and harassment training. If that training is required by law and your employer says that you have to come work during that time or come to work to do that training, then that is considered work. And what follows from why it's so important of determining what is work is because that's time that's required to be paid under the legislation, but that's also time that's counted for many important things, such as the overtime threshold and the limits on work that you're entitled to under the legislation. Generally, work is not performed under the legislation, under the ESA, during an eating period. When an employee is sleeping, I know that that's not, that's not a standard that would be applicable to your line of work, but it's in the legislation because there are types of work where people are sleeping at the office or on a train or doing whatever. So I just include it, to be fulsome. And when the employee is engaging in private affairs or pursuits. So, generally speaking, if an employer requires a registered dental hygienist to prepare for patients or clean up before or after a patient is present, generally that is considered work and you must be paid for it. And there's lots of things that probably follow from that. If you're required to do, something at the office, if you're required to do, any host of things, that's likely, by your employer, you're likely entitled to be paid for it. The ESA also has requirements about hours free from work, and there's daily requirements, weekly requirements. So I'll just give you a bit of an overview about this topic as well, because many people are surprised to hear about these entitlements as well under the legislation. So generally, you are required, or an employer is required to give employees a period of at least 11 consecutive hours free from work each day. Even if there's an agreement that your hours of work will exceed those weekly and daily limits I talked about before. Um, and there's also rules on hours free from work in between shifts that can apply in certain circumstances as well. One of the questions that we're asked a lot is, how do I calculate that, or what are the parameters around that? So as I have written on the slide, the clock on the 24 hours, it starts at the beginning of an employee's first work shift and it ends 24 after it begins. So even if you have a rotating shift schedule, we still use that period to calculate and determine whether or not you've been given the sufficient amount of hours free from work. These types of things come up probably less so in your industry, with the caveat that unless there's emergencies or there's a situation that requires you to work either a really long day or two shifts, one after the other. A lot of times this comes in handy for people who work in a factory and they have, maybe three shifts that rotate 24 hours. Um, an important reminder is that these examples of the exceptions to the hours free from work may apply and may be disregarded in exceptional circumstances. So those are emergencies, either major equipment failures, or if there's urgent repairs that have to be done on the employer's equipment. Again, these probably aren't situations that come up regularly for you, but they may come up. There may be emergencies where you'll be asked to work more than the limits, or there could be, urgent repair, less so probably in your line of work as well. Again, another question that came up a lot in the questions that many of you provided before the presentation has to do with something we call the 3-hour rule in Ontario in workplaces. And that's the situation where an employee is entitled to a minimum of 3 hours of pay for shifts that are under 3 hours, with, of course, my favorite word that you're probably finding out tonight is with a couple caveats. So this applies if an employee regularly works more than 3 hours. Let's say you regularly work 8-hour shifts. You're asked to come into work, and the owner or someone who you work for says, we don't have enough work for you today. You're going to work either no hours, 1 hours, 2 hours, or anything under 3 hours. You are entitled to, under the legislation, at least 3 hours for just showing up to work if you regularly work more than that, and you must be available to work for more than 3 hours, even if you worked less. So if you present to work but you leave early because of an illness, or prearranged time off, then you haven't met that last threshold standard in order to qualify for the 3 hours of work. So that covers that specific situation where you've reported to work, you're at the office, or your employee is at the office and they're told the patients have all canceled. We only have one patient for you today, and it's not going to take 3 hours. That's the 3 hour rule there. I'm sure there will be more questions about this when we move to the question and answer section as well. But generally, scheduling, as I mentioned earlier, is not covered under the Employment Standards Act under the legislation. But that doesn't mean that it's not covered in your employment agreement or under the terms of your employment or the terms of your employee's employment, and that you have to make sure that that's being followed. If you're told to, not come to work or anything like that, while the 3 hour rule or the general limits or provisions of work under the legislation may not provide for what happens, it's always important to consult either the policies or your employment agreement. I understand that a lot of people in the industry don't have employment agreements, and so that also might be something to just make sure that, we can talk a little bit about that as well. But ensuring that, the requirements and the terms are communicated in some way so that you understand what the expectations and what the requirements are for you or for your employees. Eating periods are also covered under the employment standards legislation. But again, people are often surprised to hear about this as well. Employees can't work for more than 5 hours in a row without getting a 30-minute eating period. So if you work regularly an 8 hour shift, you are entitled to a 30-minute eating period. If the employee and the employer agrees, that eating period can be split into 2 eating periods within every 5 consecutive hours, so long as together the 2 separate eating periods equal 30 minutes. Oftentimes we see 15 minutes and 15 minutes or 10 minutes and 20 minutes, or it is very common to have the 30 minutes all at once. This agreement can be oral or in writing. It doesn't matter with your employer or if your employee or the employees. Meal breaks under the legislation are unpaid, but that doesn't mean that your employer or an employer can't pay employees during that. Many employment contracts do provide for a paid meal break, many do not. That said, even if the employer pays for the meal break, during those 30 minutes, the employee has to be free from work in order for it to be considered a meal break. If during your meal break you are called into work or your employee is called into work to work on a patient, that meal break has been interrupted and you're entitled to the time on a different meal break. Practically, I know that that doesn't happen all the time, and many employers are not aware of that, but it does, it is under the Employment Standards Act, but it is a health and safety concern if you're not being provided with the breaks that you're entitled to under the legislation. Meal breaks, as it says on the slide, are not, whether they're unpaid or paid, are not considered hours of work. So they're not considered for the calculations of overtime. Beyond that 30-minute break after every 5 consecutive hours, employers are not obligated to give employees any other breaks. So coffee breaks or a smoking break, anything like that. Outside of that 30-minute or whatever variable the employer provides, 15 minutes and 15 minutes, there's no requirement to provide for additional breaks. Many people are surprised to hear that, and that's sometimes why employers will do 15 minutes and 15 minutes because it feels like you're getting more of a break. On this topic, one more thing I wanted to mention, as I said before, is that really scheduling isn't covered under the ESA. And one of the questions that was asked is, does my employer or do employers need to provide advance notice of shift schedules or last minute changes to existing schedules? Again, depending on what the employment agreement says, there may be really important information there about what your entitlements are. But generally, the Employment Standards Act does not provide for any minimum standards about that. So employers, I'm being cautious with how I word this, but employers are allowed to make scheduling and changes to existing schedules to a certain extent, depending on, of course, what the terms of your employment might be. A few more examples of what employment standards are covered under the ESA are topics like vacation time and vacation pay. Something that many people don't realize is that the entitlement to vacation time and the entitlement to vacation pay are two separate entitlements under the legislation. So, employees with less than 5 years of employment with the same employer or related employer are entitled to a minimum of 2 weeks of vacation time and 4% of their regular wages as vacation pay. How vacation time and vacation pay are paid are also covered, sorry, how vacation time is paid is covered under the legislation. Many employers will provide vacation pay on every pay stub, and then when you take vacation, you don't receive any earnings. Other employers will provide vacation pay as a salary continuation, which means that when you take vacation, you continue to get your regular wages. That's more common with salaried employers. And another way is that they can pay it in a lump sum before or after vacation time is taken. The next threshold is employees with 5 years or more are entitled to 3 weeks of vacation and 6% of wages as vacation pay. Those are the minimums. There's nothing beyond 3 weeks of vacation in the legislation. So in year 5 and beyond, 20, 30, 40, however many years, the legislation entitles you to 3 weeks. Though many employers do have their own greater entitlements to vacation time, it's not required. Another topic that's covered under the legislation is public holidays. They're called public holidays in the legislation, though we usually call them statutory holidays or holidays. And I've just listed the public holidays in Ontario. I feel like, and maybe this isn't a surprise to you, but I was going to say, I feel like I keep saying many people don't know this, or people are surprised to learn that the civic holiday in August, usually the first weekend in August, the Monday is normally a holiday. That's actually not a public holiday under the legislation, and employers in Ontario aren't required to provide employees with that day off at law. And what follows is that you're not entitled or employees aren't entitled to receive public holiday pay. And that's what I've mentioned at the bottom of the slide is that there are requirements under the legislation for holiday pay. And if you work that time, if you don't work that time, there's requirements around that. The Employment Standards Act also has many unpaid job protected leaves in certain circumstances that employees in Ontario are eligible for. There is one paid leave under the legislation at this time. I should say the legislation changes with anytime there's a new government. One of the things that governments like to do or not do is provide for different paid leave. So at this time, there's only one paid leave. That doesn't mean that this is going to be accurate forever or that it may not change. But right now, the paid leave under the legislation under the ESA is for domestic violence. There's certain circumstances where that leave is paid. Each different leave has eligibility criteria, a different length, and evidence that's required by the employee to provide to the employer that they're entitled to that leave. And I have some examples on the slides. There's pregnancy leave, parental leave, family caregiver leave, bereavement leave under the legislation. Um, And there are very limited exemptions for dental hygienists to these leaves under the legislation. I actually didn't know this before I was preparing for the presentation, but it does follow from patient-centered professions. There are circumstances where you can be denied a leave if it were to put a patient in danger and like very specific circumstances have to be met. But I did want to flag that there are some very limited exemptions that if they did come up, you might want to ask an employer, or if you are an employer, just to understand what those exemptions are for dental hygienists. Employees have certain rights if they do go off on a leave of absence. You're required to continue in your benefit plans if your employer provides benefits. Your seniority continues to accrue just because you go on a leave of absence, and if it's some time your employer or the employer can't say, we're not going to recognize your service during that time or your seniority, that continues throughout the leave of absence. You also continue to accrue vacation time. And very importantly, you have the right, or the employee has the right, to be reinstated to the same position that they had before they went on leave. And if that position no longer exists, an employer is required to put an employee back into a comparable position. So that's a very brief overview of some of the important minimum requirements or employment standards that we see under the ESA. But I did want to flag a couple more things that the legislation covers, because I think it's really important to know what these are from both an employer and an employee perspective, because you may not know, or you may want to request this information at some point in the future. So employers are required to keep very specific written records under the legislation. And I've listed some of them on the slide: names, addresses, start dates, dates and times that you work each day, each week, including overtime, any vacation time, vacation pay, public holidays, information about leaves of absences, and there's various time frames that these records are required to be kept by employers. As I've written on this slide as well, employees aren't required to keep written records under the legislation, but keeping certain records can be very important. The two examples that I've put are, your hours of work or your vacation or your overtime, because that can be really helpful if there's disputes, or if the employer isn't in compliance with some of its legislation. If you're keeping your own records and you know when you worked, the days, the hours, whatever it may be, that could come in handy. I'm not saying, go out and now become your own, keep your own agenda of everything. It's just, a word of advice. If you are suspecting that something isn't being followed, or you think that there might be an issue with something, it's a good idea, to keep records. Okay. What do you do if you have a concern that your employment standards are not being met? Again, this has been, a very preliminary rundown of what those requirements are, but you can raise it with your employer, you can raise it with the association, you can choose to speak to a lawyer. Um, you can also file a complaint with the Ministry of Labor, which is the body that I mentioned at the beginning of the presentation that oversees the Employment Standards Act. They have a complaint mechanism. There's a 2-year limitation period, which means that you have typically 2 years from when the act or the omission occurred to file the claim. It's completely free to do that, and you can do it by yourself. You don't need a lawyer. And what happens is the Ministry of Labor assigns an employment standards officer. They typically investigate, and based on the status of their investigation, they'll talk to the employer and the employee, and they'll make a determination. Some of the things that they can do is order an employer to pay wages, order an employer to be in compliance with some other standard if it's not monetary. But I just wanted to flag that that's something that you're able to do. There's also protections under the ESA from reprisals, which means, if you do decide to file a complaint, your employer can't fire you or can't, stop paying your wages or overtime, of course, with caveats if you do file a complaint under the ESA. That concludes the first portion, which I should have said at the beginning is much longer than the second portion. So we'll go through the workplace health and safety, and we'll leave some more time for questions after this portion. So the second piece of legislation that I wanted to cover is the Occupational Health and Safety Act. And this is a key piece of legislation that regulates the health and safety in Ontario workplaces. It sets out the policies and procedures that employers have to follow to prevent and manage safety hazards and risks in the workplace, as well as what the rights of employees are. Generally, the Occupational Health and Safety Act, or OSHA as it's sometimes called, helps employers create a safe and healthy workplace, but also making sure that employees know what their rights are. There's enforcement measures if there's non-compliance with the legislation. Like the Employment Standards Act that we just talked about, the Ministry of Labor is also responsible for promoting, regulating, and enforcing the Occupational Health and Safety Act. Throughout this section of the presentation, I might use the word employee just because it makes the most sense to us and to the working relationship. But it is important to mention that the Occupational Health and Safety Act doesn't actually use that word. They refer to workers because it covers more than just employees. So when I say employees, I am talking about employees, but just know that that's not only what the legislation covers. Um, so under the Occupational Health and Safety Act, there's a general duty clause for employers and supervisors. And that is on the slide, but it says that employers have to take every precaution reasonable in the circumstances for the protection of a worker. That is something that we come back to in my practice time and time again, because if there's something that comes up at work and you're not sure whether or not it's covered by the Health and Safety Act, one of the things to remember is that phrase, is that an employer has to take every precaution that's reasonable in the circumstances to protect a worker. So if there's, I know many of the questions that were provided in advance, dealt with specific situations that you see in your clinics on a day-to-day basis. I would ask you to consider, is that something that is my employer doing everything reasonable in the circumstances to protect me from this hazard? And that could include providing PPE if it's required under the Occupational Health and Safety Act. And some of the duties that workers have under the legislation are to work in compliance with the legislation, to use or wear any equipment that's provided or required by the employer for you to use, and also to report any hazards. So just as much as the employer has the obligation to protect the worker also has obligations to ensure that they're complying with those requirements, but that they're also reporting anything that they see in the workplace. So there are three rights that workers typically have under the Occupational Health and Safety Act, and that's the right to know about workplace hazards and what to do about them, the right to participate in solving workplace health and safety problems, and very importantly, the right to refuse unsafe work without a reprisal is the secondary part of that. So, if you have a concern about a health and safety aspect in the workplace, I think one of the questions that I saw in advance did cover that. You do have a right to refuse unsafe work if it is unsafe under the legislation. Similar to what I talked about under the Employment Standards Act, here are some of the things what an employee can do if they have concerns about health and safety in the workplace. You can speak to a supervisor or the employer. Under the Occupational Health and Safety Act, workplaces are required to have either a joint health and safety committee or a joint health and safety representative. That requirement depends on how many employees are in the workplace. And if you do have one of those that you're aware of in your workplace, you can report the concerns to them. Again, you can speak to the association, you can speak to a lawyer, and you can also file a workplace health and safety complaint online, similar to the Employment Standards Act. Both I should have mentioned, the Ministry of Labor has a hotline that you can Google the number online to call, either the Employment Standards hotline or the Occupational Health and Safety hotline to report workplace hazards. The Ministry of Labor also does a lot of proactive and reactive inspections and blitzes in workplaces in Ontario. So that's something that's important to be aware of as well. Under the Occupational Health and Safety Act, there are requirements for workplaces to be free of workplace violence and workplace harassment. This is, the specific requirements to be free from those two topics as they're defined under the legislation. And as I talked about at the beginning of my presentation that I'm not covering tonight, is also human rights requirements and human rights legislation under an entirely separate body under the Human Rights Tribunal of Ontario. there may be violence or discrimination or harassment that falls under that legislation that's not related to the workplace safety legislation that I'm talking about tonight. So just wanted to flag that as a reminder that even though I'm not covering it, that still exists. And there's protected grounds under the legislation that you're required to be free from discrimination, based on any of those protected grounds. So on this slide, I have the definition of workplace violence under the Occupational Health and Safety Act, if you want to take a second to review that. But it is essentially what you think that it might be, physical injury, physical violence, or the threat um, of that, that you would reasonably interpret as being someone exercising physical force in a workplace that could cause physical harm to a worker. Workplace harassment is the second thing that I wanted to briefly talk about that's covered under the legislation as well. And that is engaging in, and the definition is there if you want to review it, but it's engaging in a course of vexatious comment or conduct against a worker in a workplace, including virtually through the use of information communication technologies that is known or ought to be known to be unwelcome, um, or workplace sexual harassment. And I've also included that definition as well on the slide. And that can include virtually, so it doesn't have to be in the workplace. If someone at work sends text messages or instant messages, it could be advances, it could be anything that has to do with sex, sexual orientation, gender identity, gender expression. You can see the definition there on the slide. Under the legislation, employers have a duty to investigate conduct or incidents that have to do with complaints of workplace harassment, and the investigation has to be appropriate in the circumstances. There's different types of investigations that can be done. Typically, an incident is referred to as an occurrence of harassment. So, an example could be an employer becomes aware of an incident of workplace harassment by the worker who allegedly experienced it, or by another coworker who raises it on someone else's behalf. And complaints are typically defined as obviously reports of incidents of harassment, but it doesn't have to be formal and it doesn't have to be in writing. So the obligation on an employer to investigate these types of things is pretty high, in terms of, or I guess another way of putting it, it's a pretty low bar that they have to investigate if any of these types of behaviors are talked about or are raised. Even if something happened to you and you didn't raise a formal complaint by a letter, or you mentioned it to a coworker and the coworker mentioned it to the employer, that still, in most circumstances, will trigger a duty of the employer to investigate. So it is taken very seriously under the legislation. But unfortunately, many employers are not aware of what those obligations that they have might be. So that's why it's also important to equip employees with the knowledge of what their entitlements are. Here are just a couple of things that I've already talked about. Is it gossip? Is it rumors? Did it come to light after a termination? Is it anonymous? These are all things to consider when determining whether an investigation into workplace harassment needs to be done. I like to share this information because you never know if and when you'll be in this type of situation. I hope that you never will be. Um, but there are proactive steps. If workers experience harassment, you should write down what happened. um, everything that you can remember about the incident, make notes, as I've said, the date, time, who was there, the people, what was said, the order of what things happened, and you should speak to the employer immediately if you're comfortable doing that. And you can also consider complaining to the Ministry of Labor or the Human Rights Tribunal. That concludes the first two parts of the presentation. Emily, I think we're ready to move to some questions and answers. I'm
Okay,
happy to
great.
take some questions.
Thank you, Brooke. I'll just remind everybody that to ask a question, you can either type into the chat box and I'll read the question aloud to Brooke. That's for maximum privacy or just for convenience. Or if you prefer, you can use the raise hand feature and then we'll call on you to share your question in order. So the Zoom platform displays slightly differently depending what type of device you're using, but in general, the raise hand icon will appear on the bottom of the screen on a desktop, or if you're using a phone, look for a reactions icon or menu item and you can select raise hand. So Brooke, I did see one question come in while you were speaking about civic holidays. Someone says if an employer has been paying a civic day holiday pay for 15 years and then decides they no longer will pay civic day holiday, can they do this?
I think this is actually a really good question to start and set the tone of what some of the, questions might look like and how I'm able to answer them. Um, Generally, your terms of employment, are if it's in a contract, if it's not, there's something called, constructive dismissal that we typically look at if an employer is going to, let me dial back for a second. Typically, you would need to look at what the terms of the employment contract say and whether an employer is allowed to change the terms that you have of your employment. But oftentimes, if we see an established practice, it's harder to say that they can do that if they've been doing it for 15 years. It would be an entitlement that you have, but I would need to see, the employment agreement and understand a little bit more about that in order to give a definitive answer.
Okay, thanks, Brooke. I see a hand up from Cheryl. So if you would like to go ahead and unmute yourself, you can ask your question. Are you there, Cheryl? I'm going to send you an ask to unmute prompt here. Okay. I don't know if that was maybe done inadvertently. If you do still have a question, Cheryl, feel free to pop it in the chat box or raise your hand again. We do have another question in the chat, which is, I've heard of offices making staff clock out when a patient cancels or no shows. Is that allowed?
Again, it really depends on the circumstances and what your either employment agreement says or what the terms of your employment are. One of the things that we typically look for in employment agreements is because I know I don't want to keep referring to, the employment agreement and to check that. So maybe it would be helpful if I gave you some ideas of where to look or what to understand to look for. And one of those things might be, what does the employment agreement say about your requirements and your hours of work? Does it say that you will work an 8-hour shift and that's guaranteed? Does it say that, the schedule will be determined by the clinic and the employer has some flexibility in order to pay you or not pay you during that time period? So that would be one of the things that I would look for. It's it sounds like it might be something that they are entitled to do, but again, I would need more information about the whole situation. But the employment standards legislation, would allow that type of situation because you're allowed to have, various requirements under a schedule because the legislation doesn't necessarily cover scheduling in that manner.
Thank you. A few more questions popping up here. One asks, has the 6% vacation pay always been the norm for employees with more than 5 years, or was it increased to 6% in the last few years?
I shouldn't say always. It's been 6% for a long time. I don't remember, at least for the time that I've been practicing, it's been 6% of wages. Um, if you have more than 3 weeks of vacation, typically we see it as 2% based on the additional weeks, but it has been 6 weeks. Oh, sorry. Gosh, I wish it was 6 weeks, 6% for some time.
Okay, thank you. Here's another question in the chat. My manager mentioned that if the first patient of the day cancels and the dental hygienist is already on their way to work, the admin team will attempt to contact us. If they reach us and let us know not to come in, we are not allowed to clock in for that first hour. Additionally, if they're unable to reach the dental hygienist by phone, the manager instructs the admin team to wait in the parking lot. If the admin team member speaks to the dental hygienist in person and advises them not to come in, we're also not permitted to clock in until the next scheduled patient.
Yeah, and I saw this question come up, I think in advance, or a similar question was asked as well. You know, it's one of those things that it really does depend on the specific circumstances of the clinic, of your employment agreement, the terms around your employment agreement, and what you signed. Um, but again, generally, in terms of scheduling, that is not covered under the employment standards legislation, with the exception of the 3 hour rule and some of the other things that I talked about. Um, but it sounds, even if it's not permitted or not permitted, it sounds like there is some confusion with the reaching of people and then not, and if you're already on route or so I would, I don't necessarily think that there's a yes or no answer in accordance with the legislation, but it might be something to bring up either with the employer or to check what the employment agreement says about that. Where I would have an issue with it from a purely legislative perspective under the legislation is if they were trying to get you to not report to work, and then to pay you under the 3 hour rule, because then, that would be problematic.
Thank you. That answers the question. Here's another few. One is, if you are only at an office 1 day per week, how is the time off allotted?
So, vacation, I'm assuming that you're asking about vacation time and vacation pay. Generally, vacation time and vacation pay are prorated based on the amount of time that you work there. So, if your regular work week at that employer is 1 day, you accrue vacation time and vacation pay based on the time that you work. So, if you're working at that clinic 1 day per week, then you're accruing the vacation time at the rate of 1 day per week, versus if someone's working at a clinic 5 days per week, every single week, they're accruing that time for the time that they work.
Great, thank you. I see about 3 more questions here so far. The next is, if you are working as a temporary dental hygienist, but they take tax and vacation pay off your paycheck, but never get you a T4. What do you do? How do you claim your vacation pay?
Sorry, Emily, they don't take
Uh,
tax NEI. Sorry, I
says they do,
they do. And they so
but you don't get a T4.
that's a bit out of my wheelhouse in terms of taxes, but if you are treated as an employee and you have employee related deductions like CPP and EI, then you are earning, as far as I know, wages and should be provided with the T4. But in with respect to vacation pay, that's something that um, was part of what I mentioned. I didn't say this directly, but one of the things that we look at when we talk about whether someone's being treated as an employee or a contractor, one of the things is that contractors aren't entitled to vacation and vacation time and vacation pay. So that could be something, an avenue to look at, because if you are an employee, whether or not you're temporary or not, you are still entitled to those minimum requirements under the legislation, which would include vacation time. So and vacation pay. So you could always check your pay stubs too to see if you're being entitled to vacation pay. If you're talking potentially about vacation time, you may not have accrued enough vacation time in order to be entitled to it. And technically, under the Employment Standards Act, you accrue vacation in year one, but you don't take vacation until year two. Many employers don't actually enforce that. They let employees take vacation time as they accrue it, but the legislation does allow employers to require employees to take vacation after it's been accrued. So if you accrue vacation in your first year of employment, you may not be able to take it until year two. So sometimes with contract employees or temporary employees, you just may not have accrued the vacation time despite being entitled to the vacation pay.
All right, thank you, Brooke. This might have a bit of a similar answer. So someone says, question about vacation and time off requests. Most dental hygienists work in more than one office. If you are at an office 1 or 2 days a week for more than 5 years, how many days off in a row are allowed? You said a few weeks are allowed, but can those days be spread out? Also, is it up to the employer to decide when that time is taken, or can an employee book off time as needed?
So there's a couple aspects of that question that I'm going to answer because I think they're really important for people to understand and are often very surprised. So it is an employer's prerogative to approve or not approve vacation. And many employment contracts or just terms of employment generally provide for that an employer is able to schedule vacation or approve vacation at a time that's convenient for them. Another thing is that employers are allowed to schedule vacation on your behalf. It is acceptable under the legislation for an employer to say, we are going to mandate this day as a vacation day. Whether it's over a holiday, let's just say over like the Christmas holiday and between New Year's, offices close. An employer can say that we're closed during that time, and those are going to be vacation days that you're using for that period of time. Also, under the legislation, technically employers are you're required to tell employees that they have to take vacation in full weeks. Many employers don't enforce that. They let employees take, a day off here, a day off there. So I guess the easy answer to the question is it's not necessarily an easy answer, but there is a lot of control specifically around vacation scheduling and vacation time and pay that an employer is able to have much more control over an employee. A lot of things that we see is, it's not necessarily good business practice for an employer to or for employee morale to constantly not approve vacation or tell employees that they can't. But as I mentioned, that it is their prerogative under the legislation to do that. Um, Shockingly, scheduling of vacation time is covered, but not, an issue that's clearly very, very important to dental hygienists, which is generally scheduling.
Okay, thank you, Brooke. We've got a few more here. The next question is, does a dental hygienist still have the rights of an employee if there's no employment agreement? Dentist pays dental hygienists as self-employed and on commission receivables, instructs dental hygienists to become incorporated without the use of a lawyer, and if they don't, they cannot work at that office anymore. Some shifts are less than 3 hours, no lunch breaks for longer shifts, and no stop pay.
I'm not going to comment on this specific situation only because there's typically a lot that goes into understanding a situation like this. But I will say it does go back to what I talked about at the beginning of the presentation, of whether or not you're an employee or a contractor. And there are two specific tests at law that a court would consider or that the Ministry of Labor would consider in determining whether an employee is actually an employee or a contractor. But a couple of things to think about are just because someone calls you a contractor doesn't necessarily mean that you are a contractor, though many of the things that were mentioned in that question do lean towards either contractor or employee. Um, and you are permitted to work as a contractor. If that's what you want to do, you're able to work as an employee. You just have to make sure that you're protecting yourself in those circumstances, because as I mentioned at the beginning of the presentation, an employee is entitled to the protections under the Employment Standards Act, and a contractor is not, which is why specifically for a contractor, the terms that you agree to in a contractor agreement are so important, because if you are a true contractor, the legislation, specifically the employment standards legislation, won't apply to you. But again, the specifics of the situation, I would need much more information to be able to understand or to be able to comment on that further. But that's just, a general, very general overview.
That's great information for us all to know about when looking at a new employment contract.
Absolutely.
Thank you. There's a question about workplace safety. If you report unsafe working conditions, do you need to provide your name or can you do so anonymously?
That's a very good question. I haven't looked at the Occupational Health and Safety Act requirements recently from that perspective. I think you can do so anonymously if it's a specific hazard that needs immediate inspection. But there may be circumstances where your identity would need to be known. But that is something that you could easily find out on the Ministry of Labor website. If you look at filing an occupational health and safety complaint, you'll see the requirements right on the screen, and you can even look at the application to see that as well.
Perfect.
But I
So
don't want to say off the top of my head because I just can't remember specifically.
So there would be opportunity to decide if you did need to provide your name, you wouldn't be surprised by it.
Yes, exactly.
Okay, great. One question here about kind of work time bleeding into break time.
Mhm.
Someone says the manager often comes into the lunchroom while we're on break and sits down to ask work-related questions, saying things like, just while I can catch you. Do you have any comments on that?
You are entitled to a lunch break or a meal break under the under the Employment Standards Act that's free from work. I think it would be um, contingent or dependent on the specific circumstances, but someone asking you questions, who's your boss, about work while you're supposed to be having your time off, doesn't sound to me like it is a period of time that it is free from work. And I think that that is something that you could either decide to say, I'm entitled to my break under the legislation. I really need this time to be free from work so I can focus and, go back feeling like I'm rejuvenated, or however you want to frame it. And just say, either I'd like to be uninterrupted unless it's something urgent, or, am I able to take 10 minutes or however long you've taken up of my time to make up for the time that you've interrupted me. But the legislation requires you to be free from work during that time, and if you're interrupted, then you're entitled to an additional meal break.
Great, thank you. And for some examples of some wording too, that's very helpful. We just have, I think, 3 more, and then
Okay.
I think we should be good here. The next question is, are employers mandated to give a yearly review and a yearly raise?
They are not. Under the employment standards legislation, that's not a requirement to give you a raise or a review, with 2 caveats. A raise would obviously be required if minimum wage increased and your wages did not keep up with the minimum wage. Then you would be entitled to an increase because, as I mentioned, you can't work for under minimum wage. And the second is that some employers put those terms in an employment agreement that say we will increase your salary every year. That's something that you've agreed to. That's an entitlement under the contract, entirely separate. Or if they've said that they're entitled to, or if they've said that they will do a review every year, then that may be something that's required, but it's not required under the Employment Standards Act.
Thank you. It seems like one of the themes that's really coming through tonight is having things in your employment contract that will set the tone for the rest of your employment, the importance of that. Thank you. Okay, 2 more here. Is it true if you take the Friday off before a long weekend, you do not get vacation pay on that Monday?
If you take the Friday off before, is it a vacation or a public holiday? Um, there's a it's called the first and last rule under the legislation for public holiday. And I'd have to double check specifically what it says, because I admittedly haven't looked at it in a while because many employers don't usually enforce it. But usually the first and last rule is you have to work on the day before the public holiday. But the vacation, I'm not sure I have seen that before, where if you take a vacation day, then you're not paid vacation pay on the Monday. I'm not familiar with that.
Thank you. And then the last question here, since a dentist is exempt from subscribing to WSIB,
Mhm.
do they need to pay an employee if they get hurt at work?
There's, you know, it really depends on the situation of what the circumstances are, and whether you're on a leave or what happens. So that's unfortunately a very fact specific question, that would depend on, again, the circumstances, the employment agreement, and that specific practice.
Okay,
So
thank
I
you.
don't think there's a one size fits all answer to that. It's specifically related to the WSIB aspect of it.
Mhm. Okay, thank you, Brooke. I think you had one more slide you wanted to show, right?
Oh, sure, we
Conflict.
can do that. This is just my information. You can take it down. I know that that's our website. We have some blog posts to share. Again, I know that the association has their own resources for you to follow. This is, our firm information and my information. If you were looking for a specific lawyer on your own, which is separate from, and I think Emily was going to say more than that, but that's my information that I'm happy to share.
Thank you, Brooke. I would like to thank you so very much for taking the time to speak to our members tonight and providing this comprehensive overview of employment law. I know the issues you touched on have been on the minds of many of our members, and I know we all really appreciate this information. So thank you once again. I'm just going to take a couple of minutes here to very quickly just remind everyone of some resources that ODHA has to offer for some things that are potentially not falling under this presentation tonight. Just one sec here. I'm going to pull this up. One is our ODHA legal line, which all members have access to. You have access to this 24/7 with information to telephone advice from lawyers on a wide range of issues, including not only employment issues, but also civil litigation, family and divorce, landlord and tenant, personal injury, residential real estate, and small claims. So this is a great resource to use if you would like to better understand employment laws. The legal line can help as background information to you as you respond to workplace situations. If you're concerned about billing practices at your workplace, which did come up quite a bit as well, you'll want to firstly review Section 10 of the CDHO's Registrant Handbook, which is a very comprehensive guide to the standards you have to adhere to as a regulated health professional. And it includes information and guidance on record keeping, informed consent, scope of practice, and other matters. And it's available on CDHO's website. If you have questions beyond that too, you can speak with a CDHO practice advisor. They can be reached by phone or email, and they can address many of your questions. And then for dental hygienists who practice within a dentist's office, the Royal College of Dental Surgeons of Ontario, or RCDSO, has indicated that they're happy to speak with dental hygienists directly about questions related to issues in dental offices. So if you do have some of these questions about billing practices that go on in your office, that might be a good place to start. Lastly, you may want to take a look at the workplace conversation template we recently developed as part of last year's new workplace resource collection. This conversation template helps you to diffuse and de-escalate conflict in the moment and provides some language for suggesting a scheduled meeting to discuss the issue at hand. Being able to de-escalate conflict in the moment helps both parties to reflect on what they want to say and to have a more productive conversation. You can find these workplace resources by going to the member benefits menu item on the ODHA website and clicking on employment topics. That's it. And Rosie, I believe you wanted to give us all
yes.
goodbye. Thank you.
Thank you, Brooke, once again for such an informative session. This has been a most valuable meeting with such input from tonight's meeting, as well as topics that were communicated to us beforehand by our members. These opportunities for us to hear from you, the membership, are essential for ODHA's work. They help us plan the resources and member benefits, how we can enhance member benefits. We will continue to work internally as well as to meet with other oral health or regulatory bodies and association about the important issue faced by the profession of dental hygiene today. I really want to thank each and every one of you for being here with us this evening. I wish you a great evening, good night, and then enjoy the rest of the week. And ODHA is here to support you in any way. So please feel free to reach out to us for any future topics. Good night, everyone.